case briefs, and so much more. LSData's got what you're looking for.
The legal maze of Stonewall Insurance v. Asbestos Claims Management Corp., a court case heard in 1995 by the United States Court of Appeals for the Second Circuit, navigated some rather tricky terrains about the insurance responsibilities tied to asbestos injuries. The focus was whether insurance policies were supposed to shoulder the costs of claims related to the seemingly innocent act of including asbestos in construction, and the consequences that action had on humans and property. At the center of the dispute was NGC, the manufacturer of the asbestos products. They were embroiled in a wave of claims for bodily injuries and property damage, all resulting from asbestos exposure. They found themselves having to defend against numerous charges, including whether the insurance policies they held covered the claims and the extent of deductibles they had to pay. Critical to the case was the argument of whether integrating asbestos-containing materials into physical structures fell under property damage, a concept as abstract as it was costly. On top of that, the court muddled through the allocation of liability among different insurance policies, a job made more complicated by the timescale of the injuries. Under New York and Texas law, the court was prorating liability across policies, an occurrence-based strategy that sought to chart the gradual disease process. The goal was to determine injury at all stages, from installation to diagnosis of illness. This model, however, failed to account for periods during which NGC was uninsured, and the period after 1985, when asbestos insurance was no longer available. In the end, the appeal court reached a verdict that reshaped the legal landscape surrounding asbestos-related claims. First, they ruled that yes, the act of integrating asbestos into buildings was indeed property damage, and therefore covered by the policies. Secondly, contrary to what might have been logical, the court decided that NGC did not expect nor intend the bodily injuries that their products had caused. As a result, they were not liable for damages on that front. The court also eliminated repetition by clarifying that each asbestos product installation was a separate deductible occurrence. The most notable shift, however, was in the allocation of liability. NGC was held to bear the cost for uninsured periods, amending the previously adopted occurrence-based model. This landmark ruling was, however, not extended to post-1985 injuries due to the unavailability of asbestos insurance. Thus, the court sent the cancer claims back for reconsideration and further proceedings.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.